History is carved not just by empires and conquests, but by the extraordinary lengths to which humanity will go to exert control over the uncontrollable. We descend now into a meticulously recorded legal event from the 16th century, a moment suspended in the archives where the gavel fell and the natural world was commanded to obey. Picture this. The year is 1519. High in the mountains of western Tyrol, in a commune called Stelvio, the people did something truly unthinkable. They took the earth itself to court. A massive population of alpine pests was officially indicted. And this was no chaotic mob armed with pitchforks. It was a properly constituted legal tribunal. It was bound by rigid procedure, equipped with a judge, a prosecutor, and incredibly, a court-appointed defense attorney for the accused. The historical records give these accused a very specific name, the Lutmäuse, alpine worms and mice. You have to understand, in a world governed by strict hierarchy, the boundary between the human and animal kingdoms was remarkably permeable. These creatures were not viewed merely as a biological nuisance. They were branded as criminals. They were formally indicted by a legal tribunal for property damage and civil disobedience. They were actively transgressing against the divinely ordained order of human dominion. The farmers of Stelvio were absolutely desperate. Their crops were being systematically decimated from below by burrowing creatures that were quite literally severing the roots of their survival. The core of the accusations centered on the complete devastation of the Lut, the loam and soil. Without the Lut, the harvest would fail, starvation would set in, and the earthly obligation of paying rent would become utterly impossible.
This surreal courtroom conflict was drawn along strict adversarial lines. The prosecution was led by a man named Schwartz Mining. His argument was absolute. The defendants were destroying the loot, rendering the human tenants unable to pay their rents. But the legal system of the 1500s was nothing if not formal. Every defendant, regardless of species or size, deserved a voice. And so, the defense was led by a court-appointed advocate for the infestation, a man named Hans Griebner.
Griebner bypassed simple pleas for mercy and forged a genuinely brilliant legal maneuver centered entirely on utility. He claimed his clients were in fact public servants. By destroying noxious insect larvae and stirring up the earth to enrich it, he argued that the Lutmäuse were acting as silent partners in husbandry. They were actually working the land for the very farmers who now demanded their execution. The pattern of the defense suddenly shifted, issuing a direct challenge to the conscience of the court. Griebner argued that if the worms and mice were to be evicted, well, they must be assigned a new residence. And then he escalated the demands even further. It was an astonishing moment of legal gravity. A state lawyer demanding official protection from cats, insisting on state protection for rodents while they faced deportation. This heavy philosophical burden fell squarely upon Judge Wilhelm von Haslingen. He took his seat, listening to sworn testimony from witnesses who had seen the damage with their own eyes. The judge was forced to weigh the immediate physical survival of desperate farmers against the inherent divine right to eat that God Almighty had granted to every creeping thing on the earth. Finally, the gavel struck. The verdict was reached. Perpetual banishment. The mice and worms were formally ordered to leave the agricultural fields of Stelvio forever. A strict chronological boundary was suddenly imposed upon the natural world by this human court. The judge decreed a 14-day window for the creatures to comply. From the exact moment the verdict of perpetual banishment was handed down on day 1, the countdown began. By the 7th day, they were midway through their legal grace period. And by the 14th day, the absolute deadline for the eviction of the infestation would arrive, and any creature remaining would be in direct violation of the law.
But the legal machinery of 1519 then revealed its most surreal mechanism. Judge von Haslingen recognized that the rigid application of law must be tempered by equity. He granted what the court documented precisely as free and safe conduct.
This free and safe conduct took the form of a specific 14-day reprieve, meticulously drafted for the most vulnerable among the accused. The order legally shielded those mice who were pregnant or still in their infancy. It secured them against harm or annoyance from any cat, dog, or other foe, as they made their slow, forced departure from the jurisdiction. Now, you might think this bizarre mercy was just a momentary lapse into farce. It wasn't. It was actually a serious, calculated application of the lex talionis. This is the oldest kind of law rooted in human nature. It demands reciprocal justice, a formalized retaliation that requires the punishment and the process to precisely reflect the moral weight of the crime, even when the criminal happens to be a burrowing field mouse. By treating an infestation as a legal person, the community could psychologically conquer the terrifying indifference of nature. They were replacing frightening, uncontrollable biological activity with a rational narrative. The people of Stelvio were no longer helplessly losing their crops to the wild. They were domesticating chaos. They were actively winning a lawsuit against the earth itself. History dictates that by the 1700s, these kinds of trials began to fall out of favor, eventually vanishing into the archives. Yet they leave behind a disquieting mirror of modern legal logic. The primal instinct remains entirely intact. Today, our courts no longer appoint lawyers for alpine worms, but we routinely hold grave hearings for dangerous dogs, and we fiercely debate whether a sea lion possesses a legal right to eat the salmon destined for human consumption. The proceedings in Stelvio isolate a fundamental absurdity that persists right through the centuries. You see, the legal system is an institution created purely by humans, strictly for humans. Whenever society attempts to squeeze the indifferent natural world into these rigid frameworks, the animals are always left wearing clothes that do not belong to them. The historical record harbors one ultimate, devastating irony. While the judge dispensed measured equity to pregnant rodents, the people of the commune faced an unyielding human obligation. The farmers were legally required to be prompt and honest in the payment of their tithes to the church, simply to ensure the spiritual and legal theater of the sentence actually worked. The worms received their safe conduct, but it was the desperate farmers who paid the bill.
The dust of the 1519 tribunal settles, leaving behind the echo of a gavel striking wood in a high alpine commune. The line between rational justice and human absurdity blurs into a single question that echoes from the 16th century directly into our own. If the law commands it, do you give a pregnant pest a 2-week head start, or do you call for the cats?